Hey, y'all, it's me. It's your girl. And you already know. Like, sharing, subscribe. Well, y'all just come on in. I'm going to stay on here for a second or two. I just want to talk about Henry Dinkins, you know, why he didn't apologize to at least to DL. You know what I mean? Just to his son. You know, why didn't he apologize? He sat there through the whole you know, to the whole what you got verdict, and the emotions that I saw didn't really mean nothing to him. I thought about this, what I thought about. I thought about other cases that Henry could have set the example for other young folks. You know what I mean? You know what I mean? This could have helped other young people. You know what I mean? Why did he apologize? This could have opened the door for other young people, other cases. What y'all think? This could have opened the door. Hold on, y'all. For other cases. Hold on. Okay. I don't understand it. Listen to what this man said.
First degree is defined as the act of kidnapping accompanied with the intent to inflict serious injury upon such person or subject the person to sexual abuse. Kidnapping first.
And I want to know what is going through this man's mind. Why he sit here and the judge read this verdict, because this is not the same expression that he had when the women was up there on the stand. I'm trying to still get in Henry's mind. It's no way he could not feel what he did.
First degree is a Class A felony. The defendant is presumed innocent and not guilty. The presumption of innocence remains with the defendant throughout the trial, unless the evidence establishes guilt beyond a reasonable doubt. The defendant has entered pleas of not guilty, which is a complete denial of the charges and places the burden on the state to prove guilt beyond a reasonable doubt. If the state has not proven the defendant guilty beyond a reasonable doubt, then the court must find the defendant not guilty. In considering the evidence presented, the court makes deductions and reaches conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain.
Y'all see this man? Do y'all see him? How he breathing and how he looking? I mean, his emotion. What is going on in his head? Is he, I wonder, is he the kind of man that don't want nobody, don't want to let no, don't want a woman to know that he's weak? And that's not letting, if he cried, that's not telling us he's weak. I mean, he just sitting there, but I'm looking at his chest going in and out. He's breathing. He's breathing different. Is he the type kind of person that big headed? And I'm just gonna prove to y'all I am not sorry for what I did. But I thought about this case. I said that I'm thinking because I'm doing another case and I'm looking at these two guys. I'm looking at Henry and I'm looking at I'm looking at Jonathan, and they are in denial of what they did. And they took each one of them sisters. They took Breesia's brother, and Jonathan took the other sister. And the sister hid something from the other sister. The sisters hid something from the family, so she won't get in trouble with Jonathan. And here you go over here. Henry didn't hide nothing. He sneaked around and did what he did. I mean, he should have, during his sentences, I hope he apologized or say something.
Chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. The court must decide the facts from the evidence. The court considers the evidence using its observations, common sense, and experience. The court will try to reconcile any conflicts in the evidence, but if the court cannot, the court accepts the evidence it finds more believable. In determining the facts, the court may have to decide what testimony to believe. The court may believe all, part, or none of any witness's testimony. In determining what testimony to believe, the court considers the reasonableness and consistency of the testimony with other evidence, and internally, whether a witness has made inconsistent statements, as well as the witness's appearance, conduct, age, intelligence, memory, knowledge of the facts, interest in the trial, motive, candor.
I think listening to what the verdict is speaking on, the delivering from the judge. Henry knew how smart he got to know something. Because that DL was too darn cotton picking smart. He was a genius in this. He didn't forget. And I'm looking at Henry when he came home and when he got DL, he used DL to be his spokesperson. He made DL be his spokesperson. Like in Jonathan let Ayanna Sawyer, sister, SS be her spokesperson. They are cowards. They don't want to tell. So both of them in these cases took somebody else out their family who they love, siblings, and try to turn them against their own family. It's sad.
Some prejudice. The burden is on the state to prove the defendant guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence in the case, or from the lack or failure of the evidence produced by the state. If the court, after a full and fair consideration of the evidence, is firmly convinced of the defendant's guilt, then there is no reasonable doubt and the defendant should be found guilty. But if after a full and fair consideration of all the evidence in the case, or from the lack or failure of the evidence produced by the state, the court is not firmly convinced of the defendant's guilt, then there is reasonable doubt and the defendant should be found not guilty. To commit a crime, a person must intend to do an act which is against the law. While it is not necessary that a person knows the act is against the law, it is necessary that the person was aware he was doing the act and he did it voluntarily.
And that's what he did. Henry knows this. He's 51 years old. He was 47 then. He still was old enough to know what he did was voluntary. He didn't even have to remove her from the house. I'm not understanding what bees in these people like this brain. Because Jonathan didn't have to do Ayanna like that, knowing that he's her uncle. And Henry didn't have to do Breesia like that. And that's her brother's dad. They let them young people suffer with this.
Not by mistake or accident, the court may, but is not required to, conclude a person intends the natural results of his acts. Specific intent means not only being aware of an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. Because determining the defendant's specific intent requires the court to decide what the defendant was thinking when an act was done. It is seldom capable of direct proof. Intent may be shown by circumstantial evidence and the reasonable inference drawn from the evidence. Therefore, the court should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. Facts. On July 10th of 2020, Breesia Terrell was reported missing. It was not until March 22nd, 2021, that she was found. On that date, her remains were found in Clinton County, Iowa, near a pond south of the Kunow implement dealership. Prior to her disappearance and death, Breesia knew the defendant, Henry Dinkins. Her mother, Aisha Langford, had a relationship with the defendant, and as a result of that relationship, her mother had a son named DL. Breesia and her brother were only 2 years apart and therefore were very close to one another. The defendant was involved in the lives of Breesia and DL, but not on a consistent basis. Recently, before July 10th, 2020, Aisha.
That baby thick, boy. And that's who he was trying to get to. Now, in Jonathan's case, Jonathan killed this 16-year-old because she and the baby, because he killed her, he killed the baby. Because he didn't want the baby. And he left her alone. And Henry did the same thing. And they sit in the court with no kind of empathy, no sympathy. I don't get it. I'm trying to find out why. I know they sick, but geez. Are they listening?
Had discussions with the defendant, encouraging him to be more involved in his son's life. As a result, plans were made for the defendant to spend time with DL on July 9th, 2020. On July 9th, 2020, the defendant...
Why you take your breath like that, Henry? Why did you take that big breath? Let me see. Let me push this back. Why did you take that big breath like that? I'm just trying to figure this out. I just don't understand.
2020, Aisha had discussions with the defendant, encouraging him to be more involved in his son's life. As a result, plans were made for the defendant to spend time with DL on July 9th, 2020. On July 9th, 2020, the defendant
took that deep breath like that. Like, he took that breath. I can be wrong. Everything I say is allegedly. But he took that breath like, that's not what I was planning. That's not what I was planning.
To the children's grandmother's home to pick up DL. While there were discussions between the defendant, the children's grandmother, Breesia, DL, and their older brother, CS. During those discussions, it was DL's desire to have his sister, Breesia, come with him, and his older brother, CS, said he would like to come as well. The defendant approved Breesia to come along, but did not approve the older brother, CS, to come along. Although the children's grandmother did not give permission for Breesia to accompany DL during the visit with his father, Breesia did leave with DL and the defendant. When Aisha returned from work, she was informed of the events when the defendant...
Henry is really sitting right there like whatever he was doing, he's zoned out. He was zoned out of it. He's sitting here like, oh, I did that. Oh, I ain't know I did that. That's it. What's in his mind? I wish he would talk when he's doing his sentencing. I wish he would open up his mouth and talk. Because something in that man's brain, something don't happen to this man. He too old to be sitting here acting like this. This is not a kid we talking about. He needs to talk.
And picked up the children. She then gathered clothing for the children, which included pajamas for the evening and other clothes to change into, and then proceeded to the apartment where the defendant resided with his girlfriend, Andrea Culberson. When Aisha arrived at the apartment, Breesia came to the car to collect the clothing, and she was excited to see her mother and their dog, their family dog.
So the mama went out there to, the little girl went out there to the car. Okay, the little girl went out there to the car. Okay. Wonder where he was. What? Why she don't know that the little girl went out there to the car? Why she didn't know that she went out there?
After the defendant took the children into his care, they proceeded to the home of one of his friends. At that home, the children played video games and other games with the children in the home while the defendant visited with other adults at the residence. They then proceeded to the apartment located in the Jersey Meadows apartment complex in Davenport, which the defendant shared with his girlfriend of 6 years, Andrea. The apartment occupied by the defendant and Andrea was a one-bedroom apartment, which was accessed by a single exterior door that opened to a staircase entering into the open apartment located on the second floor of the building. The one bathroom in the apartment was located off the bedroom. Also within the bedroom were two closets, one used by Andrea and the other used by the defendant. While at the apartment, DL played video games in the living room area of the apartment, and Breesia played video games and interacted with Andrea while she worked remotely in the bedroom. The children were provided dinner, then showered and readied themselves for bed. The children did not put on pajamas provided by their mother for bed, but were each provided defendants large white t-shirts size 4X.
That's his solution to his problem. That was his solution to his problem. Those 4XL t-shirts. The mind was the easy SS. Something about them 4XL t-shirt turned his man on. Something. So they let you know, looking at this case, it should tell every parent something, every mother something who let their kids go. I know your dad, baby daddy ain't like that. But this would prepare you for what they need to have when they go over to somebody's house. Oh, it just. But when you know about them, if you know about your baby daddy, you got to be cautious about what you do. So the mama did bring that. I'm gonna let that go right there. I'm trying to get in this man's mind right. Yeah.
XL to her to bed. The children were allowed to sleep in the bed in the bedroom, and the defendant and Andrea were going to sleep on the air mattress in the living room area. Breesia fell asleep first, then Andrea, and then soon after DL and the defendant. At some point in the early hours, DL felt his sister Breesia kick him, and in a statement to police, remembers seeing her leave with the defendant. Subsequent to that, at 3 o'clock in the morning, Andrea awoke to use the bathroom.
If when she kicked him, how did he get her out that bed? What he do? Tap on her? He tapped on her. How did he get that baby out that bed like that? Because she kicked her brother. And when she kicked her brother, she gave her brother a hint. This not supposed to happen this way, y'all. This not even supposed to happen this way. I know when they walk on the floor, it got the creep. I can't sleep hard when kids spending the night. I can't sleep like I do because I'm not used to nobody else in the house. So I want to make sure the kids okay. So I'm not about to sleep like I do when the kids ain't over there. Andrea.
At that time, she noted the defendant and Breesia were not present in the apartment. She had not been told that the defendant left, nor that he had taken Breesia with him. She was very concerned about the situation and decided to stay up in the living room in the dark to wait for the defendant.
What? That right there, Henry. When he said this to you, Henry, when he's saying this to you, what are you thinking? Because you looking the same. You ain't changed that emotion. Are you afraid to show your emotions? I mean, it look like right now that you about to explode. It's just like you tight. It look like you tight. Look like your plaits are too tight on your head. You tight. It look like you just won't need to let it out. It seems like when you let it out, it's gonna be like a big lion. A lion. It's not you holding stuff in, Henry. They talking about a Breesia, somebody else's child, and you sitting here looking like this thing. Well, it's in your mind. I want to know what's be in their mind like that.
She realized his phone was not charged, so Andrea placed it on a charger. At approximately 3:30 a.m., Andrea heard the defendant open the door to the apartment very quietly and proceeded up the stairs very quietly, as if not to awake anyone. When the defendant arrived, he did not have a conversation with Andrea. Even though she had tried to speak with him, he would not interact with her. While at the apartment, the defendant went into the bedroom and retrieved something from his closet, which he had exclusive use of, and Andrea was unable to see the object retrieved. The court finds that the defendant either retrieved the gun used to kill Breesia or another item to facilitate his murder of Breesia.
Why you look like that? Why you look like that? You just don't care. You just don't care. Golly. He still don't care. He don't like that girl. He don't like her. Why he don't like that baby? I mean, did y'all see that? Let's look at that again.
Anyone. When the defendant arrived, he did not have a conversation with Andrea. Even though she had tried to speak with him, he would not interact with her. While at the apartment, the defendant went into the bedroom and retrieved something from his closet, which he had exclusive use of, and Andrea was unable to see the object retrieved. The court finds that the defendant either retrieved the gun used to kill Breesia or another item to facilitate.
Why he look like that? Why did he do that? Henry, I know why you look like that. Because they knew what you went in that closet to get, to retrieve. And you upset about that. Because you thought Andrea didn't see it, that they weren't gonna know nothing about a gun. Why did you turn your head like that? What is it? Need some help. You need some serious help. You need to get some help. And then you hold your head down. What's going on? What's going on? Is it only when you high? Allegedly? You might have to put it down, bro.
His murder of Breesia. The size of the revolver retrieved from the pond would have been easily concealed. Prior to the defendant leaving the apartment, Andrea looked out the window and saw Breesia in the large white T-shirt she had worn to bed next to the maroon Chevy Impala. When the defendant pulled away in the vehicle, Breesia was no longer there. The defense argues there is no one testifying they saw Breesia in the Impala. Although this is true, the court is relying on its common sense and experience that if Breesia did not go with the defendant, then she would have entered the apartment or knocked loudly to gain access to the apartment. Breesia was not familiar with this complex. If she was not with the defendant, she would have wanted to be with her brother and Andrea. The defendant then traveled to a quick shop on 53rd Street in Davenport.
Oh, they got him.
While at the quick shop, the defendant purchased $35 worth of gas, cigarettes, and a lighter, utilizing a $100 bill. The evidence establishes the gasoline purchased was sufficient to fill the tank.
Y'all, look at Henry. Do you see the look on this man's face? Like you said, he's uncomfortable. But I want them to talk. I like these kind of people like this, the kind of thoughts. I want to know their thoughts. Because the way he looking now, I don't know he gonna be able. He might not be able to make it through jail. His thought or mind just look like it just Man, I got caught this time, you know. God, why I do that girl like that? What made me that he I mean, some twist on him. He need to talk. He need to talk to somebody. Cause he gonna explode.
Chevy Impala he was operating. During this time at the quick shop, it is evident the defendant is ensuring that Breesia remains in the vehicle while he is inside the store.
What's up, Les?
From the quick shop, the defendant then traveled to the pond located in Clinton, Iowa, which is south of the Kunow implement plant. This pond is located in the intersection of 218th Street and 270th Avenue. It is at this pond that the court finds the defendant willfully, deliberately, and with premeditation killed.
Y'all see, he is just the one. He is so see, people like him didn't get away with it. And he's, like you said, disappointed. I'm looking at his facial expression. I ain't even seen him crying. I'm gonna see. But look at his eyes.
Breesia by shooting her 3 times.
Look. When you say when they say Breesia name, Henry gets so upset. He gets so when they said Breesia, it's something about Breesia. He gets so upset. This is second time when they bring up we went in the closet and got the gun. Wonder, okay, they do think they get away with stuff, and they just don't think that what they do is wrong. I mean, look at him.
The defendant then, in the process of leaving the area, became stuck off the side of the road. He then walked to US 61 and flagged down a vehicle driven by Jared Brink. Brink then proceeded to drive the defendant back to the area where the Chevy Impala the defendant was operating was stuck off the roadway. Brink then removed the vehicle utilizing a chain. The defendant offered Brink $100 for his help, which Brink refused. These findings by the court are overwhelmingly supported by all the evidence provided by the state's witnesses, particularly the brave testimony provided by DL.
See, that's y'all that man testimony. God let him talk. That man let him talk. Look at Henry, like, dang, man. Yes, he looks sicky. Like, dang, man. This not supposed to happen. I'm not supposed to lose. I'm supposed to get away with it like I got away the first time. But see, that first time with his last time, just look at him. I want him to talk so bad. I want to hear what he got to say. Because he did it. We didn't do it. That's right there. But he just look at him. Look. He put his head back up. He pushed his head back up, and he used DL, y'all. Henry had a pattern. He had a pattern in what he was doing. He didn't believe nobody was gonna believe nothing that happened. He didn't believe nobody was gonna believe nothing. He used Andrea, he used the mama, he used DL, he used his sister, he used them t-shirts, he just used anything just to get away. He thought he got away. He even lied on Vince. He lied on everybody. So this let y'all know that if you know anybody like this, you know they are a compulsive liars. They can flip it on you, manipulate you. That's what he doing. But the manipulation didn't happen in court with those judge and the attorney. See, Henry thought he was gonna. Henry would have came out better with a jury. He should have when he no he didn't he won a bench trial. He won a bench trial. See, everything is planned and planned it in his brain. And he's saying like, man, I just effed up. And the judge is sitting here telling him how he effed up. Look at him.
Did somebody say pancake party?
I mean,
Make sleepovers Chris easy.
Whew, let me slide this back up, y'all. I'm always doing something. Wow. Just want to cry.
In his statements to law enforcement,
You hear him? Trying to hold it back. That was hard for me to do, baby. I'm glad I got mine out. Hey, baby. Oh, I'm glad I got mine out. I feel you, Judge.
additionally, the testimony of Brink offered through his discovery deposition and his statements made to police. All of this was further supported by the testimony and statements made by Aisha and Andrea.
Hey, Sonny.
Their testimony and statements were corroborated by the investigative efforts of the Davenport Police Department and the FBI, except for the testimony of DL stating that he saw his father shot Breesia. The court finds his testimony credible. His testimony is supported by the subsequent investigation by the Davenport Police Department and the FBI, and additionally by his videotaped interview with the police after the disappearance of his sister. This court finds it remarkable that an 8-year-old child is able to communicate with the police with such specificity to allow the Davenport Police Department to begin their investigation. DL explained to the officers he was on a dirt road with his father and there was a hill.
Look at him, y'all. He put his head down. See, DL wasn't supposed to. DL wasn't supposed to be smart with this. He used DL as a child like he was gonna forget. He put his head down when he started saying DL. Now he mad because DL is the person that didn't mess up. God, he showed. Look at that forehead. That forehead. Oh, wait. That man is like, he's stressed. That's what I'm saying. Woo. He mad at DL now. Good. I'm so glad that when I broke down. I broke down. I'm done. That judge and Henry ain't like about to cry yet. It looked like every time he said reaction that he ought to say, oh, he did nothing. They let y'all know. Watch your kids. Watch your kids.
Which went down towards the water. Additionally, DL stated when he was with his father, the defendant explained he had earlier become stuck and he was with some fishermen. They pushed him out and he offered them $100. DL tried to explain the area he was with his father, which included seeing tractors, water, and a hill down to the water. It was not until later this statement is corroborated by subsequent discovery of Breesia's remains. The court finds beyond a reasonable doubt DL was present in the area while he was with the defendant. FBI Special Agent James McMillan took soil samples in the area where Jared Brink pulled the defendant from the shoulder of the road. Those soil samples were compared to soil samples obtained from the undercarriage of the Chevy Impala operated by the defendant. FBI forensic geologist examiner Ian Sagadorn.
Hold up. Nah, Henry ain't sleep, is it? He ain't sleep, is it? Yeah, eyes closed. I wonder why he had why them eyes closed? Wow.
Determined 3 of the samples taken from the area concentrated where the Chevy Impala would have been stuck were inclusive to those soil samples taken from the undercarriage of the Chevy Impala operated by the defendant.
He cried.
Brink came forward after the news of Breesia's remains were discovered.
I don't see no tears coming out his eyes. Man, Henry supposed to have a lot of tears coming out his eyes. Lester, he ain't crying. I don't see no tears. I don't even see not one drop of tear. And I got my whole glasses all the way to the screen. He ain't have to shoot that baby, just like Jonathan, he ain't have to shoot that baby. They had to kill that baby.
Determined 3 of the samples taken from the area concentrated where the Chevy Impala would have been stuck were inclusive to those soil samples taken from the undercarriage of the Chevy Impala operated by the defendant. Brink came forward after the news of Breesia's remains were discovered. And there's no doubt in this court's mind whatsoever he identified the defendant as the operator of the Chevy Impala, which he removed from the shoulder of the road. And that he identified the vehicle removed from the shoulder of the road. That being one operated by the defendant. Brink identified a very distinct characteristic of the defendant's face, which was a mole on the right side of his face.
Oh, look at him. Oh, when they talk about that mole, honey. Oh, he mad. Come on, Henry. He mad because the man who died recognized that mold on his face. Come on, Henry. Wow. Ain't that crazy? Oh, he mad.
Face by his nose. The white ox cord located within the vehicle, and the shorts worn by the defendant at the time he had made contact with him. All of this evidence proves beyond a reasonable doubt the defendant had Breesia Terrell within his control. He was at the site of her.
That. He had Breesia in his control. That's the key word. Control. You better not move. Don't move from right there. You can't go in the house. Just stay right there, Breesia. Stay right there. Don't do that. He had Breesia in his control. Just imagine we got a lot of them out there. A lot of Dinkins. I don't see no tear. That face skin is dry. What's in his mind?
Remains, and he was the only person who shot Breesia that early morning of July 10th.
It's now easier than ever to find affordable health insurance in Georgia. Visit georgiaaccess.gov.
Introducing Airwick Advanced Plugin with a fragrance boost button.
Oh, wait. Look, Henry shot that girl. Ain't that something, y'all? He shot that girl. He shot a 10-year-old girl who was beating on him. He shot a 10-year-old girl. Yeah, and still didn't get away with it. God, what's in his mind? I wish I could have opened up that skull and see what's going on. Son, he's stressed out. He's stressed. Could tell.
The defendant, after being pulled from the shoulder of the road by Brink near the pond located by Kuno Implement in Clinton County, Iowa, then returned to the apartment he shared with Andrea in Davenport around sunrise. When the defendant arrived at the apartment, Andrea was surprised to see the defendant in a different set of clothes. Andrea testified when she fell asleep, the defendant was wearing a white tank top and colorful shorts. When he arrived back at the apartment, he was in a white t-shirt and blue shorts. Upon his return, he took DL with him. Before he left with DL, Andrea insisted the defendant take his cell phone with him. Even during this time, no discussions were had that Breesia had disappeared. The defendant then traveled to Walmart located in Clinton, Iowa. At Walmart, his only purchase was 2 bottles of Clorox bleach. The defendant, on the way back to Davenport, stopped at the pond located at the intersection of 2018th Street and 270th Avenue in Clinton County. It is unclear whether the defendant may have stopped at this location on his way to the Clinton Walmart, but it's beyond a reasonable doubt the defendant did stop there after making the purchase of bleach at the Walmart in Clinton. DL clearly described this area in his statements to the police and by his statements of his father wiping off a large knife with bleach. DL's testimony and statements regarding this portion of the activities of the defendant are clearly supported by all the investigative evidence.
Look at him. Y'all know what the hurt part is. Henry knew that boy gonna remember that. Henry didn't think they were gonna believe DL. But DL told everything he did. It's not one time when you bring up DL name, he get upset. He let DL tell the story because he was coward. He couldn't tell the story. So he gonna let his son tell the story about his own sister. But he didn't think that they were gonna believe what her brother said. And that's the sad part about it. Now he got to live through what happened to his sister. Because she know my own daddy did that to my sister. That's why he don't like his daddy. And Henry don't never get the whole time I'm sitting here watching him psychologically. He's not upset with DL. He ain't mad at DL. But when you bring up Breesia and the mama, he don't like them. And he don't like the other man who helped him out the mud. I don't see no, but he must be crying on the inside. What you say? That's the power of this look. Oh, he got nothing left. No paper, no flip through. I'm sorry. But for the people who on Henry's side, I'm sorry. That's what you get.
State. Cell phone records of ping notifications of the defendant's cell phone are non-existent until DL places the battery back into the defendant's phone at the Walmart in Clinton. The testimony from the various officers of the Davenport Police Department and special agents of the FBI were credible as to their findings of the cell phone being disabled or dead when the battery being placed back into it. And
DL, excuse me, you two. That DL took the battery out of. Oh Lord, help me, G. DL took that battery. That battery, when that battery went in that phone, he gave his location. Look at Henry. Henry sitting there. That old boy put that battery in there. I got in there again. That's my favorite part of this trial. When DL put the battery inside the phone and started playing the game. It was smart enough to take the battery back out. That little boy right there, I tell you, he all right with me. Golly. And Henry ain't even mad. He ain't mad at DL.
Upon his return, he took DL with him. Before he left with DL, Andrea insisted the defendant take his cell phone with him. Even during this time, no discussions were had that Breesia had disappeared. The defendant then traveled to Walmart, located in Clinton, Iowa. At Walmart, his only purchase was 2 bottles of Clorox bleach.
2 bottles.
The defendant, on the way back to Davenport, stopped at the pond located at the intersection of 2018th Street and 270th Avenue in Clinton County. It is unclear whether the defendant may have stopped at this location on his way to the Clinton Walmart, but it's beyond a reasonable doubt the defendant did stop there after making the purchase of bleach at the Walmart in Clinton. DL clearly described this area in his statements to the police and by his statements of his father wiping off a large knife with bleach. DL's testimony and statements regarding this portion of the activities of the defendant are clearly supported by all the investigative evidence presented by the state. Cell phone records of ping notifications of the defendant's cell phone.
See, y'all, that's why he took them blues. Oh, look at the doggy. That's why he took that them blue shorts off, y'all. He took them blue. Henry took them blue shorts out because Clorox got on. That's why he had to take out when Clorox bleach. When bleach get on clothes, he changed shorts. He couldn't do nothing but change shorts because he had got bleach on his shorts. Ooh, bleach don't work no more, y'all. Try something else. Look at him.
His phone at the Walmart in Clinton. The testimony from the various officers of the Davenport Police Department and special agents of the FBI were credible as to their findings of the cell phone being disabled or dead when the battery being placed back into it, and the pings were registered on the various cell towers. The fact the defendant's car was equipped with an auxiliary cord to charge the cell phone further supports the court's finding that the defendant was taking actions to avoid his whereabouts being traced by his cell phone pinging on cellular towers during his travels. The court finds DL's testimony as to the smell of bleach while the defendant was wiping off the large knife, which the evidence indicates was the machete, very credible. There was bleach purchased, and the court finds it reasonable that such substance was used at the time of wiping the knife and would have been used in the area in which Breesia's remains were recovered. DL's testimony and statements are further corroborated by the fact the officers investigating this case had no knowledge of why the defendant's cell phone would have pinged in the area of Clinton Walmart. It is only due to DL's statement that he placed the battery back in his father's phone to play a game and then took it out upon his father's return from being in the store. This information led to further investigation as to the defendant actually being in the Clinton Walmart and purchasing the bleach. At the time of DL's statements, there was no knowledge of purchase of bleach. Additionally, after DL identified the knife as the machete in the exhibit shown by Detective Hammis, there was no knowledge of such machete prior to the discovery of the machete in the defendant's RV. Although machete did not revealed DNA or fingerprints, it is clear to this court it had been wiped off because there were fibers within the serrated edge of the machete. Then again, after leaving the area of the pond, the defendant traveled into Davenport and traveled in the area of his motorhome in Credit Island. Clearly, he placed the machete, which had been in his trunk, into the motorhome. The defendant called Aisha at 8:08 a.m., telling her that he had just woken up and Breesia was missing. Although prior to this time, he had been driving all around Clinton County, and at that time of the call to Aisha, he would have just been entering Davenport as he was seen traveling south on Highway 61 at 7:52 a.m. He was then in the southwest area of Davenport and near Rockingham Road, near his motorhome in Credit Island. He did not leave that area of southwest Davenport until approximately 8:26 a.m. During all of this time, there was a series of telephone calls and text messages between the defendant and Aisha. During these exchanges, the defendant advised Aisha he was traveling to the Davenport Police Department to make the report of Breesia's disappearance. Aisha then left her place of employment at Checkers on East Locust Street in Davenport and headed to the police station. It was at this time Aisha was traveling west on Locust Street to the police station. She noticed the defendant heading east at a high rate of speed.
Mm-hmm.
She then turned around to follow the defendant and caused him to stop at the McDonald's at Eastern Avenue in Kimberly. Around this time, Aisha made contact with the Davenport Police Department.
Look at him, y'all. When you say Aisha name and Breesia name, you get a different look. See, Breesia kept her mama happy because she a girl. They can do girly stuff together, like dancing and stuff at that time.
Department and determined the defendant never appeared at the Davenport Police Department, and the request was made that she and the defendant proceed to the Jersey Meadow apartment complex. They then proceeded in different vehicles to the apartment complex and met with police officers who responded to the initial investigation of the disappearance of Breesia.
Hurry to Kohl's for limited time home deals and take 15% off some of your faves for a fall home refresh.
Upon her arrival to the complex, Aisha was the first individual to meet with responding officer Craig Burkle. Officer Burkle advised both Aisha and the defendant he would like to search through the apartment to ensure Breesia.
He don't like that detective. He don't like Craig Burkle. Oh, Lord. Said that name, he got mad.
Was not hiding within the apartment. Immediately, the defendant stated she's not there and they had looked everywhere. The defendant took Officer Burkle up to the door of the apartment. When approaching the door to the apartment, the defendant knocked, which was odd since he occupied the apartment with Andrea. Andrea answered the door, was very hesitant to allow the officer in, and only allowed him in after it was confirmed the defendant consented to the officer searching the apartment. Officer Burkle then searched the apartment. Of course, Breesia was not located within the apartment, but upon Officer Burkle's return outside, the defendant was nowhere to be found. Subsequently, Officer Burkle called the defendant's cell phone at least 6 times within an hour's period, and then texted the defendant. There was no response from the defendant until he called Officer Burkle upon his entering the police station at approximately 12 o'clock p.m.
See, Henry didn't answer that phone. He's supposed to have answered that phone. That's why that detective said, why you ain't answer? When he was sitting in that interrogation room, the phone was ringing, and the detective asked him who was on the phone, why you ain't answer the phone? Or, you weren't supposed to answer the phone. Or something he said. See, Henry, I be wanting to know what's in the mind of these people because they think they smarter than other people. And they try to make everybody else crazy. But they the one got the issue.
The defendant's whereabouts were unknown for a period of approximately 3 hours. Through cellular tower pings, it was determined the defendant had traveled to his sister's home on approximately 3 occasions, which is supported by cellular analysis.
Oh, so he done been over to his sister's house 3 times from the cellular thing. So he done been over there. What he doing over there? He was over there 3 times. He was over there 3 times, y'all. Wow. What he was doing?
It is important to note that the defendant had changed his clothes from the early morning hours from the white tank top, blue and pink shorts, and gold shoes into a white t-shirt, blue shorts, and still gold shoes. And then upon his arrival at the police station, had different tennis shoes on.
So he took out them gold shoes. It's something about them gold shoes. Something about them gold shoes. They still ain't brought that up. That detective on that judge on the same thing we was talking about.
Were blue and white. Search warrants were executed for all of the vehicles, the apartment that the defendant shared with Andrea Culberson, and the home of the defendant's sister. At no time were the white tank top, pink and blue shorts, or gold shoes ever recovered at any location. They were nowhere to be found during the entirety of this investigation.
Wow.
Shortly after noon, the defendant was then interviewed by the Davenport Police Department. During this interview, the defendant was extremely evasive as to the location of the Chevy Impala. He was very evasive about his whereabouts. He stated at various times that he had been looking all over Davenport for Breesia, and that he had no knowledge of where she was at.
Wow.
He made no statement to the officer that he was with Breesia at 3:30 in the morning and gave no information about the fact that he had traveled all the way to Clinton, Iowa with DL. He also indicated to the officer that he had traveled to his motorhome to get money in order to purchase gas. Court finds a statement by the defendant completely untruthful, as he would have had sufficient monies from the change he received back from his purchase at the quick shop. He had $100 to offer Brink, and most notably in Exhibit 6-16, the officers located approximately $5,000 in $100 bills in the search of the Chevy Camaro, which was...
Wow. Henry had all that money, Henry. You should have gave that money to hit DL. You got... You should have gave your son that money, bro. Cause Andrea gone now. Andrea got that money. Got it, unless they got it. But you should have gave that money to your son. Say, hey, can you get that money to my son? Thank you. Unless you're gonna put it on your book.
Operated by the defendant and had ability to access. The only truthful statement the defendant made during his interview with the police was that he went to the quick shop. The court finds none of the statements that the defendant made during the interview to be truthful in any respect. The court finds beyond a reasonable doubt the defendant was the last person seen with Breesia.
That's right.
He had taken custody of her, had no authority to do so, and removed her from the apartment from which he had authority to care for her, with the specific intent to inflict a serious injury upon her, knowing that he did not have the consent or authority of Breesia or her mother to do so. And as a result of that removal, Breesia suffered death, which is clearly a serious injury. The court finds beyond a reasonable doubt that Breesia was shot by the defendant and that she died as a result of being shot. And the defendant did this act with also forethought, and the defendant acted willfully, deliberately, and premeditatedly with all the specific intent to kill Breesia. All this occurred on or about the 10th day of July, 2020, and the criminal activity began in Scott County, Iowa, and the defense criminal activity continued as he traveled into Clinton County, Iowa. The court finds beyond reasonable doubt that the remains located at the pond at the intersection of 18th Street and 270th Avenue are those of Breesia as a result of the testimony of the forensic anthropologist, Dr. Heather Garvin, and the medical examiner, Dr. Kelly Cruz.
Hey, Henry, you ain't crying, man. You ain't crying. That ain't no, you ain't got no feelings. Where's your feelings at? You ain't got none. What be going through their mind? Somebody got it. Oh, these psychologists need to get into the, oh, man. Jesus. Ooh, wait. In his mind.
Matthew Dean and David Baker were both inmates at the Clinton County Jail while the defendant was being held pending trial in this matter. Both of them credibly testified during the airing of a news story concerning the disappearance of Breesia. The defendant made the statement, "They are never going to find her." Both of these witnesses are credible, specifically Matthew Dean, who was no longer being held on any criminal charges, and David Baker testified he was not receiving special treatment.
Oh, look at that. Look at that. He mad at that. He mad at the one who locked up with him. He mad and he big mad. He been mad at that one who got that orange suit. Man, he went in that courtroom and told on me.
To any pending criminal charges in exchange for his testimony. Therefore, neither of these individuals had anything to gain from their testimony. Specifically, David Baker testified when he heard the defendant make the statement, he took the statement to mean the defendant knew where Breesia was located.
He did.
The court found every witness who testified on behalf of the state to be credible in their testimony. As noted, the only testimony the court did not find credible was that of DL, as to him being present and seeing the defendant shoot Breesia.
And that's the only thing, y'all. That's the only thing about DL they didn't make credible when he was grown, when he was 12 in court, that he saw his daddy shoot his sister. That wasn't credible. We are already taking that out. All us had already taken that out. So Henry, he let you know he took that out. Everything else is credible. Now what's going on in your brain?
Court's credibility findings are appropriate as statements were consistent between all the witnesses and were corroborated by the investigative efforts of the Davenport Police Department and the FBI and all other agencies. Again, it should be noted all of these investigative efforts would not have been fruitful had it not been for the information provided by DL.
Whoa, you hear that? Did you hear that? If it weren't for DL, we wouldn't know where that baby was. No emotions. He if it weren't for DL, what's up, baby? If it weren't for DL, we won't know nothing. That little boy was so credible. He need an award. He need to be on TV.
Was instrumental in solving the murder and kidnapping of his sister Breesia. The court specifically finds the defendant was not savvy in any manner. The defendant did not account for the statements and testimony of DL and that of Jared Brink. The evidence provided by these two witnesses clearly and all the other witnesses undermined every effort which the defendant may have taken to be savvy or calculated in his actions to avoid being charged and prosecuted for the kidnapping and murder of Breesia. Ruling and verdict. Count 1, murder in the first degree. The court finds the state has met its burden of proof in this case. The court finds beyond a reasonable doubt the defendant committed murder in the first degree. The court finds beyond a reasonable doubt the defendant acted with malice of forethought and willfully and premeditatedly and with the specific intent to kill Breesia Terrell, shot her on July 10th of 2020. And as a result of being shot, Breesia Terrell died. Thus, the defendant...
Shot that baby. Be ashamed himself. Shot somebody else dead, the child. Somebody else child. And sitting there and still ain't crying. Still ain't crying. Golly. Shot a 10-year-old 3 times. Wow.
guilty of the crimes of murder in the first degree. Accordingly, the court, based on the testimony of the witnesses and review of the exhibits offered in this case, finds the defendant, Henry Earl Dinkins, guilty of the offense of murder in the first degree in violation.
Like, look at him, look at him, look at him, look at him, y'all, look at him. He won't attribute it. Yeah, Henry don't want to be, yeah. Boy, you better let reality kick in, because you ain't going nowhere.
Listen.
Look, y'all. Look. He done laid his head back like he about his blood pressure up. I ain't feeling sorry for you, Henry. He lay his head back like his blood pressure high. Oh, Lord have mercy. Let his head back like that. I bet that blood pressure don't shot all the way up. Well, Henry, is your fault. It's your fault, not our fault. Yeah, he don't lay their head, that big old head on the back of that chair. You know, you should talk to me, Jesus.
Of Iowa Code Section 707.2, paren 1, paren B. Count 2.
Look. He's still shaking his head. He's still shaking his head. See, Henry tried to outsmart the judge. How in the world you gonna go send some judge A, B, C? Now the judge read his alphabets to him. Let me stop. That made me mad. Look at that lip. Henry sent A, B, this, and the judge went back and called him back with the letters that he sent him. Yeah, I know he said it. That dang DL, he put that battery back in there. Woo, DL told on him, boy. This boy right here told on his daddy, said he used you as the witness.
Woo. Kidnapping first degree.
Look.
The court finds the state has met its burden of proof in this case. The court finds beyond a reasonable doubt the defendant committed kidnapping first degree. The court
Why he get out that chair like Jane Brown? Y'all. Watch how fast he get out that chair and run out that room like he Jane Brown, boy. Boy, that boy ran out that motherfucker so fast. I didn't get a chance to look at it. He said that Henry jumped out of the chair like, I thought maybe he was going to move slow. Henry jumped out there like it was lunchtime. I ain't feeling sorry for you, bro.
Finds beyond a reasonable doubt the defendant removed Breesia Terrell on July 10th, 2020 from the apartment in which he was caring for her with the specific purpose of inflicting serious injury upon Breesia Terrell. The defendant knew he did not have the consent or authority of Breesia Terrell to do so, and as a result of that removal, intentionally subjected Breesia Terrell to serious injury, that being death. Accordingly, the court, based on the testimony of the witnesses and a review of the exhibits offered in this case, finds the defendant, Henry Earl Dinkins, guilty of the offense of kidnapping first degree in violation of Iowa Code Section 710.2. It is therefore ordered and adjudged and decreed that the defendant, Henry Earl Dinkins, is guilty of the offense of under count 1.
Wait a minute. I'm about to read what you just said, Henry. Y'all, I'm about to read. Look, y'all, I'm about got to read. Come on now, y'all. We got to read them lips, Demon. Y'all, we got to read what he said. Read his lips, y'all. I got to read homeboy lips. Come on, y'all. Let's read what he said when the judge said that, man. What you say, Henry? I ain't know you did all this.
Do so, and as a result of that removal, intentionally subjected Breesia Terrell to serious injury, that being death. Accordingly, the court, based on the testimony of the witnesses and a review of the exhibits offered in this case, finds the defendant, Henry Earl Dinkins, guilty of the offense of kidnapping first degree in violation of Iowa Code Section 710.2. It is therefore ordered and adjudged and decreed that the defendant, Henry Earl Dinkins.
What did he say? Look at that lip. Let's look at that lip over there, Henry. What did you say? What did you say up under them lips? What did you say? What did he say, Demon? What did he say, Demon? What did he say? We're gonna have to interview. I'm gonna have to interview Henry. I'm gonna have to call down there and interview Henry. He said what?
Of under count 1, murder in the first degree in violation of Iowa Code Section 707.2, paren 1, paren B, and guilty under count 2, kidnapping first degree in violation of Iowa Code Section 710.2, as contained in the trial information filed by the state of Iowa. It is further ordered an informal pre-sentence investigation report shall be prepared by the 7th Judicial District Department of Correctional Services. The PSI shall be electronically filed by noon 3 days prior to the date of sentencing. It is further ordered sentencing in this matter is scheduled for October 11th at 1:30 in the afternoon.
Wait a minute. Let me.
It is further ordered the defendant is being found guilty of force.
Hold up. Henry trying to brush me.
Found a reasonable doubt the defendant removed Breesia Terrell on July 10th, 2020 from the apartment in which he was caring for her with the specific purpose of inflicting serious injury upon Breesia Terrell. The defendant knew he did not have the consent or authority of Breesia Terrell to do so, and as a result of that removal, intentionally subjected Breesia Terrell to serious injury, that being death. Accordingly, the court, based on the testimony of the witnesses and a review of the exhibits offered in this case, finds the defendant, Henry Earl Dinkins, guilty of the offense of kidnapping first degree in violation of Iowa Code Section 710.2. It is therefore ordered and adjudged and decreed that the defendant, Henry Earl Dinkins, is guilty of the offense of under count 1, murder in the first degree in violation of Iowa Code Section 707.2, paren 1, paren B, and guilty under count 2, kidnapping first degree in violation of Iowa Code Section 710.2, as contained in the trial information filed by the state of Iowa. It is further ordered an informal pre-sentence investigation report shall be prepared by the 7th Judicial District Department of Correctional Services.
Do that man know he about to go to jail for the rest of his life? He just sitting in jail like he on the porch smoking a do he know what? Do he know what's going on? Do Henry know what's going on? He said, "You right." Oh, Jesus. Whew, y'all so funny.
PSI shall be electronically filed by noon 3 days prior to the date of sentencing. It is further ordered sentencing this matter is scheduled for October 11th at 1:30 in the afternoon.
Okay, y'all. Oh, man, at 11. Oh, man, I told you 11 at 1:30. I'm going to be at work. Oh, no. I ain't going to be able to go live. I have to come home and pre-record. I'll be at work at 1:30. Dog, man. I get it though. Oh boy, I do it. Look, y'all, but now y'all got to see the end. Watch when he get ready to do the Jane Brown, get up out that mother sucker.
It is further ordered the defendant is being found guilty of forcible felonies shall remain in the Scott County Jail pending sentencing without bond. Thank you.
Look at him. Ran out that motherfucker. Damn, he said bad nothing.
As we just heard, Henry Dinkins has been found guilty for the murder and kidnapping of 10-year-old Breesia Terrell, both counts.
Dinkins' sentencing is scheduled for October 11th. Our crime reporter Linda Cook is in the courtroom, and we have more crews outside of the courtroom as well.
We'll be sure to bring you reactions to the verdict on Local 4 News throughout the day and on our website at ourquadcities.com.
Green Gainer. Henry mad. He mad at y'all. Oh, Lord, Jesus. He mad at y'all, boy. That boy Henry, y'all. What we gonna do with Henry, y'all? What we gonna do with Henry Dinkins? We got another one. We got to get out of here. We got to get this other. Oh, Lord. And it said, you right. Boy, that right there. That y'all be for real. To be honest, that right there, they need to get in his brain. They need to. All right, y'all. Look, it's 1:07. I act like I ain't got to get up in the morning now. Look, we said wait until. He said wait till he go back. Where did he go back to prison? He going to run it back. Y'all got me crying. Y'all got me crying. Y'all got me crying. All right, y'all. I gotta get up with my early morning. But to be honest with y'all, in the morning, I really don't be talking about them in the morning. I just be trying to get people that come to go to work with me, ride to work, and keep me company. So I just be talking junk in the morning. What do touch screen mean, y'all? Touch screen game over. What that mean, Captain? What do touch screen game over mean? I'm slow with stuff like that. But my early mornings, workers and everybody, y'all, yeah, in the morning time when I go live at 5:30, I just be one of them at 5:10. I just be wanting them to keep me company in the morning time, y'all. So I just talk about anything. So, but I did put some, I did upload some videos for y'all, okay? Y'all make sure y'all comment on it. All right, gang. I appreciate y'all being here with Dinkins. Now we got to get Jonathan Quillis in jail too. He going to jail, period. He gonna get the death penalty too. He next. All right, boo. I'll talk to y'all tomorrow. I'm out. What'd you say? What'd you say? I love you. I love you too. I'll be right with you. Okay. I'll see you in the morning. All right.